What's the item number? Regarding item number 5, let's say, we did not get the paper book lot.
5.
Five.
Paper book prepared.
Paper book prepared lot.
Okay, then it won't matter.
Huh?
It is submitted on behalf of the appellant. No, the respondent. That's number 2. It is submitted by Ms. R. Rongmai, Learned Counsel for the respondent number 2. That copy of the paper book is yet to be furnished to her. Full stop. Let paper book be furnished to her as well as any other counsel to whom it is yet to be furnished. Full stop. List after
Next
2 weeks.
2 weeks.
List after 2 weeks.
2 hours also lot. Paper book may be
We said all. But is it prepared?
prepared lot.
Yes, its numbers is there, 6 numbers. Okay.
Item 1. May it please your lordship. Lordship, this is a statutory appeal for against a conviction under 302, my lord. There are 3 numbers of appellants before your lordship, and their father and sons, my lord. Conviction under 302. As of now, my lord, the appeal may be admitted, and along with it, lordships, 1 interlocutory application for suspension of sentence has been filed for 1 of the applicants, my lord. Out of the 3 appellants, 1 has come for the IA. My learned senior, probably because 302 should prefer to file an objection.
I heard Sri D.K. Buddha, no? Learned Counsel for the appellants, who has preferred so and so, admit, call for the records. Miss B. Bhuya, Learned APP, accepts notice on behalf of the state respondent. List after 6 weeks along with report regarding receipt of LCR.
Lordship, with regard to the IA, my lord, because
I will issue notice. Heard Sri D.K. Buddha, who has filed this application under so and so, praying for suspension of so and so. The connected appeal, being appeal number so and so, has been admitted today. Para. Let notice be issued. Returnable by 6 weeks. Miss B. Bhuya, Learned APP, accepts notice on behalf of the state respondent, who may file objection in the meantime.
My lord, with regard to notice, maybe that might not be necessary because the state is the only respondent, my lord.
That is, we have to issue notice. He has accepted.
My lord.
My junior will accept the note.
Okay.
A does. R does.
Orders. Okay. Okay. Through Miss Ardas. Okay. You don't know the name of your junior.
Yeah, there is J does also, my lord. One more junior.
Obliged.
Ramdhan.
That's
Ramdhan.
it. It's folks.
Who's in the other side?
Let's see, they have filed a color nama, but
Last
on-
time was the
no, on every occasion, let's see, they are not present.
Mr. Chitawat, MD.
Let's see.
Where is Mr. Chitawat? But are they aware of this matter? Their names have been shown.
Let's see. But they have not appeared on any occasion. As a live streaming, maybe.
That will take care. Don't worry.
My lord, these are two.
Irrigate. No, citation. Without this, what is? What? But we control. Yes. Okay, written argument is okay, but we'll sell. Yes,
Two discrepancies were pointed out. One,
now we are in the midst of the hearing, we have not come.
Now, my lord, if I can just recapitulate the submissions within 2-3 minutes, my lord, what was argued on the last occasion. And then I'll take your lordship to the other part of the arguments, my lord. I'll not take your lordship to the depositions like PW 1-2, because on the last occasion, we have substantially covered the deposition. My lord, here is a case, my lord, if your lordship remembers, my lord, where the SSB, the Sashastra Shiva Bal, they have intercepted a car, two vehicles. They have intercepted two vehicles at 3 a.m. in the night in a jungle area in Arunachal Pradesh. Kya naam tha? Ankling More. Thereafter, my lord, the SSB team was divided into two groups. Now, the one group was 9 kilometers apart from the other group. So the group which has intercepted the vehicle, they have brought both the vehicles down 47 kilometers to their base camp. Somewhere in the morning, 4:30 a.m., my lord.
Yes.
Thereafter, my lord, they have called the NCP personnel from Guwahati. The NCP personnel reached the Udalguri base camp at around 7:30 in the evening. Thereafter, my lord, the seizure procedure was done at around 9:30. And my lord, the next day, my lord, they have, my lord, am I making sense? So, my lord, at 7:30, the seizure procedure started. The seizure procedure was over by 9:30 in the night. The next day morning, these samples were sent to the FSL, and then charge sheet was filed.
Mr. Kyle, the entire thing would, the FSL would play a very major role
yes,
here.
sir.
Apart from that discrepancy which you remember regarding some
Yes,
other
sir.
witness
Yes,
signing,
sir.
he's one of the prime witnesses.
Sir.
But the FSL, if it is for a different sample, how do you connect it?
Lordship may please to come to page 100.
My
100.
lord, may I just finish, my lord?
I will come back to you. Just trying to have some clarification. Page 100.
Lord.
আৰু বেলেগ ফাইলো আছে নেকি হেৰি না মোৰ নোট এটা আছিলে ক'ত গ'ল নোট কৰিছিলোঁ নোট আইচিআৰত নোট আছে নেকি নোটটো আছে নেকি কিবা এনেকুৱা সৰু নাই ন তাতে নোট নাই ন এটা নাই ন নোটটো শুনানি কৰিছিলোঁ শুনানি কৰিলে মই নোট নকৰাকৈ শুনানি নকৰোঁ যিয়ে নোট কৰিব লাগিব page 100
No, Lordship, 114.
114
Lord.
yes
The letter whereby the samples were sent to the FSL.
yes
I'm reading the letter dated 39/2018. Kindly find here with 17 numbers of original samples marked as S1, S2, S32, S17. Properly waxed seal with NCP brass seal number 04, which was drawn in connection with NCP crime number so during seizure of 102 kgs of ganja. Center. Now, Lordship, page 99 is the report. The exhibit C.
page 99
99 is the report. Lordship.
yes
I'm reading the content of the letter, the report. Your memo number 22 advising the examination of one parcel. Per speed post, which was received in this office on 59/2019 in connection with 22. Mode in which the parcel found to be pegged on ship and the description of ship. The parcel consists of 17 exhibits, putting enclosed in a steel envelope. But the facsimile of the steel was found to be Narcotic Control Bureau 04, matching with the sample. Now let's see description, then result. 17 numbers of seal envelope marked as S1 to S17, respectively, having 17 numbers of closed polythene pack, one packet in each envelope containing 25 grams of .70. Then result, the examination of DN41 to DN41 A17, a positive test for cannabis ganja. Now let's see main crux of the evidence of PW4, page 12.
Page
12.
yes,
A small perspective I am
yes, yes.
clarified. On 59/2018, while I was posted as Joint Director Drugs and Narcotics Division Director of Forensic Science, Assam Padipada, file member number 20 dated 39/2000, I have received one parcel per messenger in connection with HCV crime number of 2008. The parcel consists of 17 exhibits, two enclosed in a seal envelope. The facsimile of the seal was found to be Narcotic Control Bureau number 4, which matching with all the documents. Now description of article. Three sealed envelope marked as S1 to S17, consisting of 25 grams of plant each mark. Here 20. Then result. Here is a problem. The exhibit DN.
No problem is also with the description.
No, lots of description is three.
Description is also, there is a problem. Three
Okay.
sealed envelopes. You see there, 17 sealed envelopes.
Three sealed envelope.
You come to page 114 or page 99, even in the description. Three sealed envelopes cannot be 1 to 17. 17
17
number.
numbers of seal envelope.
Yes. Here he says three
Yes,
numbers.
Yes, yes, three. Yes. Mark A, S1 to S17, consisting of 70 grams and so. And there is this description is there. Then result of examination, exhibit DN 246 to A2. There is a problem. There, lordship, may please to see the cross.
Yes.
The dry plant materials which I received, examined
This
as
is four,
whole.
this is three. This can be held to be an error. Should be exhibit 3.
Yes, my point in lordship, in cross examination, when yes, there is some discrepancy. You can say this is a typographical.
No. Cannot be.
No, no,
Typographical error in an NDPS case
No,
of
no, no.
exhibits. No
lordship,
way.
I'm just placing one judgment. Lordship,
No
for
way.
constitutional lordship.
No way.
It's 1998, 1999, 8 SCC page 508. I'm just reading the from the digest I'm reading.
1999.
1999, 8 SCC page 508.
Just a minute, please.
1999, 8 SCC page 508, paragraph 6.
$508.
Yes, 508. Name of the party is Bombay, sorry,
Sarjudas.
Sarjuda, state of Gujarat.
Paragraph?
Paragraph 6.
Yes.
Seal on the packet shipped by the forensic science laboratory reading. Police Inspector Sabarmati, Ahmedabad City, PSI deposing before the court that the seal affixed on the seized articles was of a police inspector Sabarmati. Specimen of seal sent to the laboratory, also telling with the seal, the packet sent to it. In such circumstances, held the small lapses in position of PSI could not provide ground to hold that the seal on the packet was a different one, and that the material seized was different from the examined in the file lab.
It's a seal.
No, Lordship,
It's here is exhibit numbers are different.
yes, that is there.
It's the
Lordship.
seal of the brass seal, number
No, no.
4, or there can be some other number. That's a different contention.
Regarding Lordship, the samples were sent. These are matching. The seal also matching.
But he
But
gives a result for another sample.
No, Lordship, but the description is almost similar, Lordship, except 3, close to 17, it is even 17.
No, not that. Come to the last part.
Yes, Lord. The
Yes.
exhibit number so and so. This is a
Exhibit
quite
number,
different.
where is 246?
It is not there.
It's not there.
It's a
These
mistake.
are different.
It is a lot. Correct. I'm not
Totally different.
I'm not defending that. It has been
4A to 4C, these are some other 3 samples.
and Lordship will be see that in cross examination, yes, discrepancy is there, but in cross examination nothing was put on. Lordship, interestingly, in judgment also the novel trial court referred the same thing has been repeated.
So that is why he is before us.
No, Lordship.
Trial court should have taken into consideration this.
Yes, Lordship, and regarding PW2, nothing has been mentioned in the and I make inquiry from the execution witness of that officer also. They said that on that day there were 3 or 4 cases were fixed. And
See what has actually happened. We are not too much
No,
bothered
okay.
or concerned.
so for
He has he's trying to make out a case. Why shouldn't he take this as one of his main grounds? That's a deposition of A, sign is by B.
yes, Lordship, that is
Why not?
it is there. Lord.
Your mistake, your inadvertent mistake, your intentional mistake, we are not bothered.
No, Lordship. This is
What was
serious-
the learned trial court doing this?
Yes, Lordship, this is my question, Lord, for you, Lord. Because this is a case of
No, we are
Not
not
between-
judging that. We are on the judicial side, examining the decision. We are not going to the who's making the decision.
no, Lordship.
We can, as is required, we can criticize the judgment. We cannot criticize the judge
No,
on
Lordship.
on a judicial side.
My point for
Administrative side is a different matter.
discrepancies are there. It is apparent on the face of the record. I cannot defend also. But
On
Lordship, my-
this, it will go
no, Lordship, I'm
on this
nothing-
itself.
I'm
On
nothing
that part, matter, somebody else's sign, that is also very important.
No, yes, Lord.
And
in case of-
here, when, had it been some other evidence, this is the main evidence.
No, Lordship, I'm not defending anything which is contrary to the law. But my point before your Lordship, with regard to
So far as the
PW4,
second aspect is concerned, exhibit 4 has been written instead of 3.
One-
To that part, we can, there is
that-
no 4, it should be 3.
yes, Lordship, that is,
It should be 3.
yes, some mistake is there. I'm not defending anybody, Lord. But with regard to PW4, PW2, Lordship, this is the serious lapse. And my humble submission, Lordship, there should be a thorough inquiry by the registrar
Regarding what?
regarding why this thing happened. Because this is a serious lapse. Prosecution may be responsible, the judicial side also, court may be also responsible for that.
That we may not endorse.
No, this is my humble submission. Consideration of a lot, whether a lot is considered or not, that is what order will it pass. But there is a discrepancy is there. That is apparent on the face of the record.
My lord, in this case, there are 6 such, this is just the tip of the iceberg, this FSL report. There are 6 such defects in the case, which one in itself are sufficient for acquittal. My lord, where are the ganjas? Where is the contraband? Neither the contrabands were produced before the court, nor any inventory was produced. The very seizure is a theory. Where are the contraband?
The contrabands are not, 100 kilos of contraband are not required to, will you produce an elephant before the court?
Yes, my lord, in
You're
NDP,
not, you can prove the inventory.
there is no inventory.
There, Mr. Cal?
No inventory. That is what I say. Where are the ganjas? This is a
Ganja
theory.
The ganja are not required to produce 100 kilos of ganja. Why should they transport it to the
No,
court?
my lord, my lord, my lord.
But inventory, yes, Mr. Kyle,
Yes, it
inventory
is
is not
there.
produced.
No, no, there is no inventory.
What's the page 95, Panchanama?
Panchanama and inventory are different thing, my lord. Panchanama is a report prepared on the spot. Inventory is prepared under 52A. My lord may see the list of exhibits which your lordship will find at the
Panchanama
paper
is
book.
there.
Which one?
Panchanama is there.
Yes, Panchanama and inventory are completely different thing. Panchanama is more like an inquest report.
Total weight of the suspected ganja is 102.500. This has been exhibited.
Yes, this has been exhibited.
Exhibited.
It's not that there is no basis of this. There is.
My lord,
Yeah, okay, you make your submission, but একাডেমিক সকলো হেৰি কৰি ল'ব লাগিব মেনশ্যন এটা কৰিব লাগিব পাছতো কৰিব খুজিছে যদি কেইটাত উঠিব লাগিব কেইটাত উঠিব লাগিব যোনকেইটা পইণ্টকেইটা জাষ্ট আমি মেনশ্যন কৰি আমি এইটো পইণ্টতে আমি ডিল কৰিবলৈ বেলেগ ডিল কৰিব নালাগে বুলি কম আৰু আমি সাষ্টেইন কৰিব নোৱাৰিম ন এইটো বেয়া কৰিব লাগিব নহয় নেকি নে কি কি
my lord,
just September 19, 2019. I'm married. September. So that is- Yes, what is it?
now my lord, Panchanama is prepared on the spot. 52A is an inventory. Simply mere preparing of an inventory will also not suffice. It has to have a certification of the magistrate. Then only it becomes an evidence of the ganja. In an NDPS case, my lord, the
NDPS. Yes.
52A is a completely unique provision in NDPS case. And there is a mandate, my lord, will see.
Okay, you formulate your points.
Yes, I'll formulate my point
please
and then
address it. But you have to do it 3:15 we are rising.
well, 3:15, I'll do it within 3 months. Formulation part at least.
Just formulate. Because,
Formulation part.
see, just thinking aloud, we are this appeal may we not know, but most likely on the basis of page 12 only some decision has to be given. But since you are urging some other points, let us at least try to note what are your points.
Yes. So, my lord, there are judgments of the Supreme Court which
52.
with 52 capital A. There are judgments of the my lord, I'll just formulate the point and then I'll take your lordship to this provisions, my lord.
Please have your seat, Mr. Kar.
Under 52A, my lord, an inventory is required to be prepared and there is a mandate in as much as, my lord, he cannot prepare an inventory out of his whim. He cannot write an essay on what had happened on that day. That inventory has to contain the origin, the my lord, to be precise, shall prepare an inventory, section 52, subsection 2. Yes. Such containing such detail relating to their description, quality, quantity, mode of packing, marks, numbers, or such other identification particulars of the narcotic drugs and psychotropic substances, controlled substances, or conveyances, or the packing in which they are packed, country of origin, and other particulars as officer referred to in subsection 1 may consider relevant to the identity of the narcotic drugs, controlled substance or conveyance in any proceeding under this act, and make an application, my lord, this is important, and make an application to a magistrate for the purpose of certifying the correctness of inventory so prepared. And the magistrate is given and the role of the magistrate is in the next subsection. Where an application is made under subsection 2, the magistrate shall as soon as may be allow the application. Then comes, my lord, that if he allows, then it becomes a primary evidence. Subsection 4, my lord, will see.
Yes.
Subsection 4, notwithstanding anything contained in Indian Evidence Act or the Code of Criminal Procedure, every court trying an offence under this act shall treat the inventory, the photographs of narcotic drugs, psychotropic substance, controlled substance or conveyance, and any list of samples drawn under subsection 2 and certified by magistrate as primary evidence in respect of such evidence. Neither the ganjas was produced nor this was produced. There is no primary evidence. The entire interception of ganja is a theory. This is my second limb of argument. My lord, there are umpteen number of judgment. I can immediately recollect 2 or 3 where says it is mandatory to produce ganja during a trial in an NDPS Act. The ganja's packet will be, I'll give all this. The ganja's packet will be produced in the court, 1 or 2 packets. If the defense counsel insists, it will be opened. It will be shown that yes, it contains ganja, nothing else. Because, my lord, the more stringent the provision, the more strictness of proof is required. I'll come to the judgment part. For the time being, I'm just keeping it. My lord, I'll come to the judgment part later.
Now you can cite the judgment side by side.
My lord, my written argument, in fact, contains everything. My third limb of argument, my lord. Third limb of argument is,
Yes.
the samples were not drawn before the magistrate.
What is it? Samples?
Samples not drawn before magistrate. Hence, violation of section 52, capital A, subsection 2, and full bench decision of the Honorable Apex Court rendered in Mohanlal, Union of India versus Mohanlal and others, 2016, 3 SCC 379, para 15. To be precise, I'll just take the conclusion, para 31.1. That's the direction. Followed by, this decision was followed by the Honorable Apex Court in Mangilal versus State of MP, 2023, SCC online, Supreme Court 86. My lord, all these are all there in my written argument. I have given all this under each head.
What is the statute which has been violated?
Section 52, subsection A, subclause 2. Sorry, section 52, capital A is the substantive provision, subsection 2. My lord, may I read?
Section 2 you have just read.
Just read. That is only one part of the subsection is regarding inventory.
Yes.
The next part is regarding drawing of sample, preparing list of samples, and the drawal of sample. My lord will see. Containing such detailed description, narcotic packing, and all these things. Subsection 2, there is clause B. Taking in the presence of magistrate photographs of such drugs, substance or conveyance, and certifying such photographs as true, or Number C, C is where I am harping on. That is what the Supreme Court has interpreted. Allowing to draw representative sample of such drug or substances in the presence of such magistrate and certifying the correctness of any list of samples so drawn.
But these are all or disjunctive.
My lord,
All or A, B, and C are all separate or.
my lord, here the Supreme Court interpreted it, the procedure for drawing of samples, my lord. Now it is it is a settled law, my lord. I cannot even use the word almost once the Supreme Court has decided. Now the Supreme Court says samples has to be compulsorily drawn before magistrate. One judgment I'll prove. Supreme Court says, I will not go into any other aspect. If you do not comply with the mandate of the full bench judgment of this court, samples not drawn, acuted, no other evidence even discussed. I will even show that judgment, Mangilal. This 2016 judgment cropped up from a confusion that was created by an standing instruction 1/89. There was an standing instruction by the central government under section 52A that you draw the samples at the spot where recovery is made, my lord. Then, my lord, this discrepancy came up before the Supreme Court. Now, there was an apparent discrepancy between section 52 subsection A, the mode how samples are to be drawn, and the standing instruction. Supreme Court says when there is a conflict between an executive order and an act, the act will override the executive order, and hence it was made clear that it is a wrong procedure to be followed. Mandatorily, they will have to draw the samples before a magistrate. So this is my third limb of argument. I'll just, my lord. Now, my lord, somebody will have to say, in this case, my lord, somebody will have to say that I have seen Mr. X carrying the ganja. Somebody will have to say, direct evidence, circumstantial, somebody, that I have seen Mr. X doing this offense, carrying this ganja. This case is based on a hearsay evidence. Now, my lord, this case is based on hearsay evidence. My lord, the raiding team on that day, the raiding team was divided into two teams. Each team was 9 kilometers apart from the other. It is, I can understand a case, my lord, where the distance is 500 meters or 600. It is like one team is in High Court, the other team is in Jalukbari. 9 kilometers apart. I'll show from which evidence I am reading. Now, the team which has intercepted 2 vehicles, out of this, the team which has intercepted the vehicle, out of all the team members, they examine only one team member. That is PW1. PW1 in cross-examination, he fails to identify the person, the appellant who was in the dock. He said, I don't remember. So there is no evidence to connect the alleged recovery with the appellant. The question is this, my lord. Why did they withhold the other members of the team if actually this man was in fact intercepted on that day? Because my lord will appreciate, here is a case where at night 47 kilometers, these people were dragged from, were brought from one place to one state to another, in fact. My lord, one more glaring deficiency, which again calls, my lord, for interference with this order of on its own count. Now, my lord, according, my lord, just now the counsel for the, this is NCB case. The counsel for the NCB relied on one forwarding letter, if your lordship remember. The forwarding letter is dated 13/9, page number 140. The letter through which the samples were forwarded to the FSL. So meaning thereby that either the samples were drawn on 13 or before 13. It cannot be post 13 because 13 is the date of forwarding letter 114. Now, my lord, I have checked the records, my lord. I'll just beg your lordship indulgence to kindly take up the record of the case one. Kindly see the order of the magistrate dated 1610. 1610 order,
This is your fifth ground.
fifth ground. 1610 order, my lord, will kindly see. My lord, this, my lord, with, I will ever give us record. This,
1610.
on 2610 order, your lordship will kindly see 2610 and 3010 order. It is there in the record, man. 2610 and 3010 order. That is 43 days after the samples allegedly sent to the FSL. The FSL was correct. He did not identify these samples to be ganja. 1610, my lord will see.
1626.
2610, my lord will see. 2610 and 2610. Order of the learned trial judge.
26.
Order sheet, your lordship will see.
Yes.
My lord will see the order sheet, what is written there, my lord. On 2610, an application is made to draw sample before the magistrate. Along with an application for destruction of the sample as contraband. How can it be, my lord, after 43 days? Then what were those things which were sent on 13/9? Whether at all any samples were drawn in that case, God knows. Now, your lordship will see the next order, 3010. Their application for drawal of the sample was not allowed. Only destruction was allowed.
सबसे डाঙৰ কথা হৈছে কিন্তু পঠিয়াইছে কেতিয়াবা মই পঠিয়াইছে এইটো ইছলাম তলবি আপোনাৰ দেরি করেছে এক্সামিন করেছে এই কোন দরখাস্তকে কি হবে 26 না 26 জন দরখাস্ত দিয়ে স্যাম্পল ড্র করব ওখানে তো একটু তাহলে আগত কেন এইটু করবো কোথায় সে একটু 21 নম্বর অলরেডি এজ বিলিভ করি কিন্তু কি স্যাম্পল করতে হবে স্যাম্পল ড্র করে 52 একটু মোটে তো এখন দরখাস্ত করেছে when was the Caesar made
Caesar 13. Caesar 13 and FSL received it on 15.
no
On
no Caesar
13, 13 तारीख, 13. 13/9.
the interception
Interception 13/9, Caesar 13 that very day because morning 3 a.m. therefore same day. In the evening 7:30 the Caesar was done.
the application of 52A when will it come
Fif-
the drawing of sample will come immediately isn't it not will it come later on
Cannot. It will come the very, my
the
lord.
moment it is says it should come
Yes, it should come immediately if the Caesar procedure, if the Caesar procedure is done after rising of the court, then it is kept in the Malkhana, everything with a proper receipt, and the very next day it is
Yes,
exited.
Kyle, your response on this because there are apparent discrepancy has shown he has taken us to the records of the case where there are 3 applications made by you
Lordship, it is
on
correct.
26/10
I've gone,
2008
I've gone through the record, it is correct.
and
Approximate,
the 30/10 there was an order passed order is not very clear but order let us assume that the order has also allowed you to draw samples
that is reflected in judgment also, Lordship. Because sample was drawn on the same day. Yes, it is, there
but
is a
that will violate 32A
Yes,
52A
52A. Yes, Lordship, that is correct. There is our High Court division judgment is there, Supreme Court is also. But there is an explanation to that. If you Lordship consider that, I will make. But samples were drawn on the same day on 13/9.
but
And-
we'll continue this tomorrow okay you make your this was your last point
One more, my lord. That is why I said, my lord, in this case, I have got, my lord, 6.1 in itself is sufficient for acquittal. I did not even travel to the next point. Admittedly, my lord, and that is why, my lord, there is a big connection. That is why the FSL expert did not has deposed test result regarding some other samples. My lord, off the record, I can understand what might have happened. My lord, this is not what might have happened, my lord, from my little experience, my lord, what might have happened in this case. They have drawn samples from this. Now they have to furnish a report under section 57 to their superior officer. They furnish the report. This is off the record, my lord. They furnish the report. Their superior officer have detected this blunder which they have committed. That how could you draw sample in the absence of magistrate? Try to rectify it. Then some officer have made this application unmindful of the fact that already samples were drawn and sent. This was a damage recovery process which they have undertaken. So an inquiry is to be directed against the NCB official. Anyways, my lord, I'll come to my legal submissions. Now, my lord.
was there any report from the magistrate
No.
regarding 13/9 regarding earlier 13/9
13/9 magistrate, I have not come across any report. No certification about inventory, list of sample, photographs.
see these application and the order passed are by the special judge
Yes.
okay but prior to that was there on the state of the seizure
Mhm.
or the interception was any approach made to the magistrate no
So I could not find in the record. My lord, in fact, what they do is that, whatever I understand, subject to correction, in NDPS cases, my lord, they bring it to the special judge only. They don't go to the magistrate because the special judge exercises original jurisdiction, 437 bail
No, no.
application.
But for the certification and for drawing of samples.
They-
it
they-
does I mean, into one.
Ilaka magistrate, they approach the-
approach.
In some cases, I have found, in most of the cases, Ilaka magistrate, but there are cases, my lord, which I have personally done, that produce it before the special judge also. In Kamrup also I have come across.
No, that.
Be that as it may, there are, those are
that-
aberrations.
They can, that's up to them, but there is no requirement. Rather, it is not needed because samples here, confiscation was done or the interception was done somewhere in Udalguri.
Hmm.
No point of coming all the way to Guwahati with the sample to
No,
get
no,
the
it's-
certification.
No. Special judge Udalguri. Udalguri session judge is the special judge. This is not PC Act, my lord. In PC Act, there is one special judge in Assam. In NDPS Act, every district, there are special judge.
In this case, there was a special judge.
Yes. He
The
has.
session judge has exercised powers of
Yes.
special judge.
All session judges are vested with the power of special judge under NDPS. There is a notification to that regard. And this impugned order is in fact passed by the Udalguri special judge.
That we have seen.
Yes. So,
তেওঁলোকে স্পেচিয়েল জাজটো কৰিব পাৰিছে বা কৰিছিল কিন্তু পিছত কৰিছে 26/10 কৰিলে অলৰেডি ইণ্টাৰচেপশ্যনটো হ'ল 13/9 কৰিলে এমাহতকৈ বেছি দেৰি
43 days to be precise. Now, my lord, the last point, the last argument that I'd like to make. Now, my lord, Section 55 of the NDPS Act mandates regarding safe custody of the contraband.
Yes.
55 says, lays down that immediately on seizure of contraband, you will have to deposit it to the nearest police station. And the officer in charge of the said police station, after making necessary entry in the Malkhana, will keep it in his safe custody. Now, I put a question to myself. Will it be okay if a seizing officer or any officer of any investigating agency, NCB, DRI, state police, any officer of any of the investigating agency, if he keeps the samples in his personal custody? Justice, my lord, 2018, 17 SCC Supreme, my lord, all are there in my written argument with paragraph also I have quoted. I'll just read one line of that judgment.
2018-17 SCC
627 para 8.
name.
Name Mohanlal versus State of Punjab. This is a separate judgment, but this is also 3-judge bench judgment and authored by Justice Gogoi.
Yes.
Now, I'll just read 4 lines of para 8. The view taken by the High Court that under Section 55 of the NDPS Act, that PW1 was empowered to keep the case, property and samples in his individual safe custody is completely erroneous. On the face of it, the provision reads as Section 55 was paraphrased, and then a plain reading of the provision makes it manifest that it is the duty of the police officer to deposit the seized material in the police station, Malkhana. Now, here is a case. My lord will kindly come to page number, paper book. My lord will kindly come to, I have handed over the seized to the, yes, page number 17 of the paper book, what the seizing officer says, page 17 of the paper book.
Yes.
My lord, I am reading 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11th line from bottom, which starts on the right hand side with the word on 14/9/2018.
Yes.
Now, my lord. Seizure was made on 13, my lord will just bear that in mind, my lord. On 13/9 seizure was made. On 14/9/2018, I handed over the seized articles to Udalguri police station, police Gudam, sorry. On the same date, I again handed over the original sample and money to NCB office. I did not submit the reason for not handing over the articles to Udalguri police station, Gudam, on 13/9/2018 itself. Now, my lord, at what?
What was the timing?
Yes. 9:30, my lord will see the seizure list when the seizure procedure was over. My lord will kindly come to page number teaser list of page number to discuss.
Mr.
Yes,
Vishwas
92.
will continue tomorrow. Today,
Part third and tomorrow as item.
reference, we'll have it.
Could I show that teaser list?
No, tomorrow we'll have it. Today there will be some. Tomorrow we'll hear Mr. Kyle also.
Lordship,
I will give reference to this matter so far as hearing is concerned.
I have item number one, court number one. After
Item number one will be over. We'll have some admission matters.
Sure.
And he's yet to complete.
I'm deeply obliged.
But since you know the trend of the court, you can just cut short your argument. and-
Absolutely, my lord. I'm trying to make it as short as possible, man.
How can I get a hold?
My lord, just one bit. On the last occasion, I submitted a written argument. I'll just would like to take that written argument, and this may be taken on record. On the last occasion, there was
That is damaging to you.
not damaging, some points, some more points.
Mr. Kyle has already read that.
No, 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 I don't know.
He has a copy of that, photocopy. And
Copy
he'll-
has not been given.
tomorrow we'll see his reaction.
Copy
Ah,
has been not been given to me.
Paucity of time. Paucity of time did not permit the matter to be taken. Up to date, full stop.